Okay, thank you very much. I've just sort of put together a bit of a presentation to kind of give people the heads up on the new chain of responsibilities laws, core laws. That's an acronym that I'll use a lot. I hope it's not too off-putting. And I'll assume that I'm talking to councils. It won't really matter. If you're not from a council, if you're a contractor, you'll still understand what I'm talking about. And I'll also have a bit of a focus on contracts as well, but if you've got day labour in your council, you'll also understand what I'm talking about. So the chain of responsibility concept encompasses a range of compliance requirements, all listed there. The new laws will come into place in the middle of the year. All of these risks need to be considered with reference to the new legislation. Mass compliance is probably going to be the most important one for, or the most significant one for waste collection vehicles, and I'll focus on that a bit today in my commentary, but risk assessment and compliance considerations will need to be given to all of those listed. So there's a range of legislative instruments. I've just listed the New South Wales ones there. They'll be embedded in the individual state road and transport laws and administered by the state authorities. These amendments have a significant impact on the obligations of all parties in the chain of responsibility, and they substantially increase the maximum penalties. For corporations, you're looking at maximum penalties. There's categories of offences, and for the most important offences, the maximum penalties excuse me, have increased to up to $3 million fines for corporations, and for an individual, $300,000 and up to 5 years imprisonment. So they're very serious, and people should be taking these new laws seriously and making sure that you're compliant. The new laws require corporations both not to breach the relevant limits for each of those core components that was in the last slide, and secondly, to have in place business practices aimed at proactively ensuring compliance and avoiding non-compliance from occurring. So even if there's no incident or accident, a corporation can still be in breach of the duty if it does not have in place the required practices. I've heard some councils, when I've been talking to them, say that they don't really need to read too much into this. I'm sorry to tell you that you are a party now to the chain of responsibility. For contracted services, council is the consigner of the transport activity, and for day labour councils, you will be the transport operator and the loader. So day labour councils' compliance duties are going to be much higher. So all parties in the chain of responsibility have either a primary or a secondary duty. So your duty is that you are responsible for ensuring, so far as is reasonably practicable, the safety of your transport activities wherever you're using a heavy vehicle. So if you're running a heavy vehicle around the LGA 52 weeks a year, you will be deemed to fully understand your duties when it comes to chain of responsibility. The secondary duty there goes to where you will have a council with a contractor, but the council's responsibility will be to ensure that your actions or inactions do not result in, encourage or reward or provide an incentive for any other party in the chain to breach the limits. So the definition of transport activities is important in the legislation, and it includes business practices. So parties in the chain of responsibility are required to have core compliance policies and working procedures, core compliance induction and training, core compliance assurance contract terms in any of their supply chain contracts, and core compliance assurance systems. I expect that we will start to see these responsibilities captured in quality management plans or integrated quality management systems, but as yet we're not seeing that, so we have to treat them separately. So what does the council share in this responsibility? Primary responsibility if you're the driver or operator of the heavy vehicle, and the shared responsibility. The amendments articulate a shared responsibility whereby the safety of the transport activities relating to any heavy vehicle is the shared responsibility of each party in the chain. So the amendments impose general duties on all core parties to prevent and avoid breaches, and in addition the amendments recognise that parties may have control or influence over road transport activities, even when they're not physically undertaking the activities themselves. So what does that mean? Basically it means that all parties in the chain may be held liable if they did or could have exercised control or influence and didn't do so. So that's what I've got in that slide. If you have control or influence, you are a responsible party and you could be liable. Control is taken to be the actual control and responsibility of the vehicle and or the potential to exercise control over an activity, including exerting indirect control through influencing the conduct of other parties in the chain. Oh, there was another point there. Executives, that goes as far as making sure that executives' due diligence duties are undertaken. So for municipal contracts, the council is the consigner. They're drawn into the chain of responsibility by virtue of their contracts, and the contracts will be taken to be the transport documentation for the purpose of the new laws. So there's no escaping it. So what do you need to do? I think there are four main areas that councils sort of need to be aware of. I'll talk about each of them. You need to implement compliance assurance conditions in your contracts. You should request certain information from other responsible parties in the chain. You should ensure that there are no award arrangements which encourage or reward non-compliance, and you should implement active risk management systems. So the first one, compliance assurance. So if you're going to tender or you've already got a contract in place, you need to revisit those contracts and include compliance requirements. So this is about minimising risk to councils. You need to be able to ensure that you've got all the systems in place that you need. If there's a prosecution and you're drawn into the chain, you need to be able to sustain a defence. So you need to establish systems that will help you prove that you did everything that was reasonably practicable given your position in the chain. So these sorts of things will include requiring the contractor to comply with the core specific laws, conduct relevant hazard and risks assessments, also probably require the contractor to consult, cooperate, coordinate reporting with council, and you also need to ask the contractor to provide sort of information and documentation for the purpose of you being able to properly monitor your responsibilities. So a core management plan is something that we're going to see typically in contracts from now on. And we also need to look at your other contractual powers as well. So we need to see whether or not your show cause notice allows you to require the contractor to do what you need them to do in this area. And things like suspension of payments and termination clauses, they all need to be re-examined as well. The second thing is requesting information. Importantly, councils need to get their own data in order. This is a difficult area for some councils, but it's a very important one. Particularly if you're going to tender, councils should provide tenderers with historical data to assist the tenderers to structure the services and design suitable control measures. So that includes things like providing data on collection route load mass totals, and not just a one-off. We need to be able to indicate seasonal fluctuations in the data, so probably monthly. Over the last couple of years, you'll need to start gathering that information. This might mean that you have to ask your current contractor for it so that you have it and you start building on your data. Screening through a tender phase is important. So you require the tenderers to provide supporting documentation in relation to their core compliance. The major waste contractors are all over this, so it's not a problem to ask them to demonstrate that. Fleet details are going to be very important, and the tenders that we've been running recently, we ask for a very detailed fleet schedule to be provided. It's a very useful tool for councils, not only in the tender evaluation but in the contract management as well. But that fleet inventory is also going to be handy for understanding that you've be able to prove that you're compliant with the core responsibilities. Council should inspect the fleets, not just at the outset of the contract, but periodically throughout the contract, to make sure that the fleet's being utilised in the way that is compliant with the core laws. As mentioned, core management plans, that's going to be basic requirement, and those core management plans we should require in the contracts that they're updated and resubmitted to council probably every contract year. Award arrangements. This is a very interesting area of, if you're not asleep already, you must ensure that there are no award arrangements which encourage or reward non-compliance with the core laws. So you have to consider the industrial instruments upon which your contract is based or upon which you're operating your day labour services. A couple of things to consider are the timing. If you're going to set strict time constraints on when a contractor can start and finish collecting, you've got to understand that they have to comply with the core laws. So that might mean that's additional trucks if you've got strict time limits on collecting. Payment structures, they should not encourage or reward non-compliance with the laws. So payments based on time, the old job and finish, if there's still any job and finish arrangements happening, then they're probably finished. That would be a behaviour that the courts would see as encouraging non-compliance. Payment structures. The courts are saying, the common law position is that payments based on weight are not preferred. I know we're seeing councils write strategies now where the proposal is to start collecting on weights, but if this flows through to industrial instruments, the courts are saying that a payment structure based on a fixed integer is preferred, like households in a collection zone, for example. That's a preferred payment structure to a payment on a variable integer like weights, which directly impact on the compliance requirements. And we also need to consider the other payment arrangements within industrial instruments, things like bonus payments, anything that might encourage somebody to breach the core laws will be frowned upon. So this is the fourth area that particularly councils need to be aware of. This is really what the chain of responsibility is all about. You should be checking your invoices. Do they have collated mass reports with them? If they don't, you need to ask for them and you need to look at them. You need to ensure that the contractor is reporting non-compliance, and particularly any incidents that occur. You need to understand what the contractor is going to do to remedy any of those non-compliances, because if you're not asking those questions, you're not really acting reasonably in your responsibility. And if the contractor's not responding or providing the information that you're requiring, you need to consider what steps you'll take, and that may include reporting them to the relevant authorities as part of your own risk mitigation. Did you see that one already? Oh. Oh. I just threw this one in because often people ask about what if they've got their weighbridge themselves. Well, the case law has suggested that where the council owns or operates the weighbridge, it's probably reasonable to expect that a council would act on any overmass loads in real time rather than waiting for a report to come back to a waste manager. So that will mean that councils who are operating weighbridges, or anyone operating a weighbridge, will have to have a core management plan for the weighbridge. So just in summary, you need to consider whether or not you need to update your contractual requirements. The duties will start when the laws come into force, so there's no point, you can't just sort of wait for 12 months to update. You need to do it now. Any systems, if you've got a day labour council, you need to consider, and councils with facilities need to consider if they need core management plans, systems put in place. And that's all I was really going to talk about, so I'm happy to take questions. Yeah. If you're operating the weighbridge, you'll be required to act reasonably. So if you're a council that operates the weighbridge and it's your collection vehicles coming around and they're overweight, your duty at that point will be higher than if somebody just comes off the highway and you know if you've got all the tar weights of that vehicle, of the collection vehicles in your system at the weighbridge, and you can tell it's overweight, your duty to step in would be greater than if somebody just came off the highway that you've never seen before and had an overmass vehicle. You may not even know that it's overmass when it's weighed because you don't know what the vehicle capacity is. So you'll just have to, these are all the things that you need to work out in your core management plan. Some of them might be very difficult to implement if you're in a remote area, because your plan might be to tell the guy who's turned up with an overmass vehicle, okay, you park over there and we'll have to deal with you, you know, have steps to deal with you. But if you're in a remote area, you can't get a RMS operator out there, or inspector out there very easily. So you're going to have to develop, according to your own circumstances, you'll have to develop a core management plan. But the reasonableness will also go to you maintaining a weighbridge that is accurate, and that you're maintaining that, periodically. So you'll have to look at the circumstances of your own weighbridge and design your own core management plan.